Okay, everybody, I'm going to take you through Van Wyck's case in this short video. The video has actually turned out, I think it's going to be a little longer than I expected. When I got into Van Wyck's case, I realized there's a lot of meat on the bone here, and I didn't want to just leave certain things out. I actually decided what I'm going to do is let me go through this case because it gives such a great example of how the courts actually approach expert witnesses. There's a lot packed into the case. We won't be able to get to everything, but the approach that I've taken is let's have a look at all the key features that come up, because it's such a good example of how things work in practice. Alert you to a couple of key features, and then we can, in future training, I will then unpack those individual components. So this will be a bit of an overview, but there will also be quite a bit of detail, and I hope you'll take something useful away from this training. I think it'd actually be very useful. Just even this video alone, I think will be very helpful. All right, let's get into it. Okay, this is the This is the SAMLR trial subscription induction training for experts, and we're having a look at the case of Van Wyck versus Dozier and another. For anybody watching this video that isn't aware, there's training material available on the Medico Legal Reports website, and you've been referred to certain paragraphs of the case as background reading. In fact, it should also just be stated again that this entire case is capable of being read by an expert witness. It is a little bit of reading. I would suggest that it would be worth at least just trying to make your way through the case, see how far you get. Don't expect to understand everything. This video will guide you through the essential points. But why I would suggest you try and read the case is because it'll get you familiar with how case law actually works, which is the end result of the whole judicial process, and gives you quite a nice orientation. So don't be intimidated by the case. It's been selected so that it's something that you should be able to follow most of it. There will be certain things you won't, but that's not serious. This video will explain those aspects. So let's have a look at the relevance of the case, why it's been chosen. Firstly, the facts related to a dispute between experts. What's nice about that is it therefore accentuates some of the key principles about dealing with expert evidence and how the courts approach that. And so you'll see that the approach to the assessment of expert evidence is discussed in some detail. What's nice about this case is that the real classic cases is referred to and summarized in this particular case. So that's also very helpful. Then what is more is, in many cases you don't actually have a dispute between experts and the court doesn't grapple with those principles. But in this case, that did happen. And so the court also has a look at what are the general legal principles relating to a dispute between experts. Very useful. Another aspect, another feature that does come up, but it's very useful that it's also summarized in this case, is the difference between scientific and the judicial standard of proof. It's something comes up in general discussion and generalized training quite a bit. Here's a very nice recent example of the judicial application of the difference between those two standards, or the judicial approach, I should say. It does apply it, but it discusses those two standards of proof quite nicely. And then finally, it's a good example of the courts applying a number of key principles to specific facts with an emphasis on the approach by the courts. I've just dealt with that. And those, as I've said, those specific principles will be developed in subsequent training. Each one of these principles, which we've set out on this page, is actually merits a presentation on its own. So we'll take a sort of bird's eye overview at these principles. Very nice to have them all summarized together, I must say, in this case. All right, so let's have a look at some background facts. The first defendant, a doctor, Dr. D, performed a total hip replacement, THR, on the plaintiff, Ms. Van Wyck, who was at the time 73 years old. It was common cause. In other words, it was agreed between the parties. It didn't need to be established in court. The court approached the facts on the basis that the surgery was performed with informed consent, so that wasn't an issue. and that the post-operative care and management were acceptable, so post-operatively there was no problem. It was further common cause that the plaintiff suffered a permanent sciatic nerve injury during or as a result of the surgery, which resulted in inter alia a permanent drop foot. So there's the injury itself. And we're going to have a look at how the court approaches this question. Now we get to the actual issue. Now when we look at a judgment, it's very helpful to consider what were the issues in the judgment, because that will guide you to what the court actually decided and what they commented on. In this case, there was only one issue, and that was whether the intraoperative damage done to the sciatic nerve was as a result of the negligence of the defendant. So negligence came sharply into the spotlight. However, you'll see done was as a result of the negligence. In other words, yes, negligence is in the spotlight, but hidden in that particular issue is another one, and those experienced practitioners should already have identified causation. So was there a causal link between any negligence and the injury? So it's as if the structure becomes question 1, was there negligence? Question 2, we know there was an injury, that's common cause. She suffered a permanent sciatic nerve injury during or as a result of the injury. We saw that in the previous paragraph. And the next question is, was there a causal link between the injury and any negligence which was established? All of that must be proven by the plaintiff in order to succeed. All of those what we call elements of the claim. Incidentally, the plaintiff did not proceed against the second defendant, Mediclinic Limited. It obviously had instituted action originally against Mediclinic, but then did not proceed at trial stage. Some sort of settlement may have been reached, or it may be that the case against Mediclinic was withdrawn. The judgment doesn't tell us, but it's not relevant because they proceeded against the plaintiff, and that's what we're interested in. Okay, let's have a look at the nature of the negligence alleged by the plaintiff. Now we get into the nitty-gritty, if you like, of the negligence. Was the incorrect and careless placement of a retractor during the THR procedure. That's the specific ground now of negligence. But remember, even if it could be established that there was incorrect and careless placement of the retractor, the inquiry wouldn't end there, right? Remember, we've just had a look at the previous paragraph. It would also have to be established that there was an injury as a result of the surgery. Now we've got that. That's what's called common cause. But there would then have to be an inquiry into causation. So that's how often this question of causation comes up. How we can see the interplay between injury, negligence, and causation. Those three, there's a sort of a dance that goes on between the three. And at the end of the day, the plaintiff must prove, in accordance with the judicial measure of proof, which we will look at later, that all three of those elements are present. Okay. So as you can see, there's quite a lot bound up in this matter. But these are fundamentals of a judgment. What we're going through now are really the building blocks of medical malpractice judgments. Okay, let's have a look at the next slide. Then at the trial, the plaintiff called a Dr. N to testify as an orthopedic expert in her case. We don't like to use the doctor's surname for training purposes. Our preference is to avoid identifying individuals. There's no real percentage in that for training purposes. And we do like to respect the professional standing of individuals where training occurs. Obviously, in some contexts, it's necessary to disclose the name, such as when the judgment is printed, because that's how the judgment is handed down, and also with various search features. But for our purposes now, we're just going to refer to Dr. N. And then the first defendant testified himself and called Dr. J as an expert. The expert's attempt at compiling a joint minute was not successful, so they couldn't prepare any JM at all, with no final joint minute having been signed. The sticking points being the cause of the injury and whether the defendant was negligent. Now, Dr. N was a retired orthopedic arthroplasty surgeon and emeritus member of both the South African Orthopedic Association and the South African Arthroplasty Society. So, well respected, good, strong expert credentials. Over the course of his career, he had performed approximately 6,000 hip replacements, of which 4,000 were primary hip replacements and 2,000 revision hip replacements. So Vastly experienced, both in his status, his standing, and in his direct experience in practice. Very, very important. So Dr. N was firmly established as somebody that the court would be prepared to listen to as an expert. We do deal with that in other resources, establishing the expertise, quite nicely established here. Dr. N had sight of all the relevant reports in this matter, as well as the hospital notes and billing accounts of the defendant. So it looks like he'd had quite comprehensive materials at his disposal. It's another something that you check. Looks like that box is ticked here as well. Then Dr. N agreed with the report of the defendant's neurologist, Dr. S, that there was a direct relationship between the plaintiff's sciatic nerve injury and the surgery. Okay, so what we've got here is a direct relationship. In other words, causation is on that sentence was established. So the injury and the surgery are linked causally. He also agreed with Dr. S that if the sciatic nerve is compressed, it is both the lateral and medial parts of the nerve that is involved, and the patient will have problems lifting the foot up, as well as stepping down and turning the foot inward and outward. He also agreed with a schematic representation in Dr. S's report of the close relation of the sciatic nerve with the hip joint. So all of that is common cause, not necessary to even debate that. All of that has been agreed. Most importantly, this causal element, insofar as there's a direct relationship between the injury and the surgery is concerned, was established. Then Doctors N and B had attempted with Dr. J through a process of elimination to find the most probable cause for the injury to the plaintiff's sciatic nerve. So now we've got Dr. J entering the picture. What is common cause between all the parties? Let's have a look at that. During the course of this exercise, Dr. N excluded thermal damage such as electrocautery, since no cement was used. He also excluded traction, the overstretching of the leg during surgery, as a cause of damage to the sciatic nerve, since the plaintiff's leg length was found to be normal during examination by the experts. Dr. N also found compression by hematoma pressure to have been unlikely, since the amount of blood drained from the wound post-operative was only 20 mL. Dr. N was of the view that the most likely cause of the injury to the sciatic nerve was due to incorrect retractor placement. Critical. We're now getting to his view of what was the actual cause of the injury, and you'll see most likely cause of the injury. What does that tell you? Experienced experts should be picking up that is probabilities, judicial measure of probabilities. In other words, that's the test that needs to be applied. What's the most likely cause of the injury? And here we have Dr. N's view, or put differently, Dr. N's opinion. He explained that a retractor is the fifth hand during surgery. The surgeon's and his assistant's hands are not enough to keep the wound open to gain access to the joint. Because the sciatic nerve is so close to the hip joint, incorrect placement of the retractor can cause damage to the nerve. Though the sciatic nerve is not visible with the lateral approach to the hip joint, it is a big nerve, and the surgeon should know where it is. According to Dr. N, the first thing you are taught as a registrar is to be aware of the sciatic nerve and to take the necessary care to protect it at all times during surgery, the so-called golden rule. Placement of the retractor over the sciatic nerve could cause damage to the nerve with its sharp edges, or could cause pressure on the nerve leading to ischemia and inadequate blood supply. Dr. N was referred in this regard by Mr. Williams, SC, for the plaintiff, to literature which emphasized the importance of the careful placement of retractors around the acetabulum in order to prevent or reduce the incidence of nerve damage, with which he agreed. So the fact that the careful placement of retractors is a potential cause of injury is borne out by the literature, and of course Dr. N's opinion is that it was the retractor placement that is the most likely cause of the injury. Dr. J then, let's have a look at what Dr. J's view was. Dr. J explained that while he disagreed with Dr. N and Dr. B that there was a direct retractor injury to the nerve, since he could not find direct injury, he could not eliminate an indirect injury by way of a retractor or anatomical variant. So he couldn't eliminate that potential cause of the injury, the retractor. If there was no anatomical variant, then in 99% of the cases, placing the retractors at the normal position would not cause nerve injuries. In the 1% of cases which present with sciatic nerve injury, there are risk factors such as female phenotype or anatomical variance because the sciatic nerve is not where it is expected to be. All right, so Dr. J's opinion is now being developed. Now let's look at it more even further. Although Dr. J could not deny that retractors are always a possible cause in typical sciatic nerve injury, so it's a possibility. But do we meet the judicial test of probability, more than 50%, or most likely cause? All of those expressions really come down to the same point. He maintained that the injury in this case was atypical for any sciatic nerve presentation, as well as for retractor compression, because both the common peroneal as well as the tibial nerve were injured. So now it's always possible in typical sciatic nerve injuries, retractor placement. In this particular case, we've got an atypical injury. Then he goes on to say, neither he nor Dr. N could find a direct relationship with a specific retractor being placed at a specific point during the operation which was responsible for the injury. So you don't have that direct evidence. That always makes it more complicated for the plaintiff. He could not find any evidence that a retractor had caused the sciatic nerve injury and did not agree with Drs. N and B, who in any event could not give a reason for their opinion of retractor damage. The approach to, now, so there you've got your dispute between the experts. Now the court needs to assess which expert was right, Dr. N or Dr. J. They agree on certain things, but they're crucial areas of disagreement. Let's then have a look at the approach to expert evidence. And this is the classic case on the approach to expert evidence. This is how the courts assess expert evidence, and it's very instructive. Michael versus Linksfield Park Clinic. That is a crucial medical malpractice case dealing with experts. Possibly, arguably the most important case. And let's have a look at why. Michael's case says the following. In the course of the evidence, counsel often asked the experts whether they thought this or that conduct was reasonable or unreasonable or even negligent. The learned judge was not misled by this into abdicating his decision-making duty. In other words, the judge, although the experts are asked what is reasonable, what is unreasonable, ultimately the judge must make the decision. Nor are we sure that counsel intend that should happen. However, it is perhaps as well to re-emphasize that the question of reasonableness and negligence is one for the court itself to determine on the basis of the various and often conflicting expert opinions presented. As a rule, that determination will not involve questions of credibility, but rather the examination of the opinions and the analysis of their essential reasoning, preparatory to the court reaching its own conclusion on the issues raised. So I just want to spend a minute on this. So the court said that you must re-emphasize the question of reasonableness and negligence. Now, reasonableness and negligence in law is connected because the test of negligence is whether the person in question acted reasonably. If you didn't act reasonably for legal purposes, that's negligence. When it comes to expert witnesses or expert practitioners, medical practitioners, who can be held to a higher standard than just the ordinary person, they look at the reasonable standard of that particular branch of the medical profession. So you must have conducted yourself in a reasonable way as a surgeon in performing the operation. If you failed to comply with that standard, you were negligent. So there's that link between reasonableness and negligence. And then the key point here is that the court must examine and analyze the essential reasoning of the experts, and then the court must arrive at its own conclusion. In other words, the experts present their evidence, the court considers it, assesses it, it gains an understanding through the expert evidence, but the ultimate test, and this is the key point to emphasize, is that the court is assessing a reasoning process. It's that logical, step-by-step reasoning that underpins everything that an expert does. What is required in the evaluation of such evidence is to determine whether and to what extent the opinions advanced are founded on logical reasoning. There we go, exactly what I've just said. That is the thrust of the decision of the House of Lords in the medical negligence case of Bolito versus City and Hackney Health Authority. Very important case, a British case, but it's been imported into South African law. With the relevant dicta in the speech of Lord Brown Wilkinson, we respectfully agree. Remember, we're dealing here with Michael's case still. So Michael's case is referring to Bolito and agreeing with the principle in Bolito. Summarized, the principles are to the following effect. The court is not bound to absolve a defendant from liability for allegedly negligent medical treatment or diagnosis just because evidence of expert opinion, although genuinely held, is that the treatment or diagnosis in issue accorded with sound medical practice. In other words, merely because there is a consensus of opinion amongst medical practitioners, even if they genuinely believe it, that does not necessarily bind the court to find that there was negligence. In other words, the courts will not defer to the body of opinion of medical experts just because they say it is the case. The next sentence throws light on that statement. The court must be satisfied that such opinion has a logical basis. In other words, that the expert has considered comparative risks and benefits and has reached a defensible conclusion. In other words, the courts will not simply follow what an expert believes a standard should be, or a failure to comply with that standard, depending on the case, but the court will have a look at the essential reasoning process of that expert, and indeed, if necessary, at a whole body of opinion. If a body of opinion is not reasonably held, if it's, for instance, it's not based on facts, it's not based on scientific facts, or the court finds that as a matter of probability, it can't be established that the consensus of opinion is valid, then that may very well not be enough, and the court may find that the plaintiff has not discharged the onus of establishing on a balance of probabilities that the standard was not met. Let's have a look at that. If a body of professional opinion overlooks an obvious risk which could have been guarded against, it will not be reasonable, even if almost universally held. So that, to me, is just an example. I don't think the court there was trying to say the only thing is if there's an obvious risk. I think it's more demonstrating the broader point that if the body of opinion is not logical, then the court will not regard itself as being bound. So, for instance, if an obvious risk is not considered, the court may say to the expert, but what about this risk? Oh, this body of opinion hadn't really considered that. The court may well say, well, then in those circumstances, I'm not prepared to follow the body of opinion. In my view, that risk needs to be considered before I'm prepared to find that that opinion is valid. Let's have a look at the next slide. A defendant can properly be held liable despite the support of a body of professional opinion sanctioning the conduct in issue if that body of opinion is not capable of withstanding logical analysis and is therefore not reasonable. Now, I just want to place my last few remarks and the last few slides in context. We will look at this in the next sentence, but I just want to start by saying that the most important point that I'm making is that it is the logical reasoning process of the expert evidence which is central to the points that the court makes and which we are making at this stage. In other words, the court assesses the logical reasoning process and will not just blindly apply the opinion of an expert, even if that expert is supported by a body of opinion. Having said that, this is very important. The essence of what the court was saying is to highlight the logical reasoning process. You'll see from the next sentence. However, it will very seldom be right to conclude that views genuinely held by a competent expert are unreasonable. The assessment of medical risks and benefits is a matter of clinical judgment, which the court would normally not be able to make without expert evidence, and it would be wrong to decide a case by simple preference where there are conflicting views on either side, both capable of logical support. Only where expert opinion cannot be logically supported at all will it fail to provide the benchmark by reference to which the defendant's conduct falls to be assessed. I just want to unpack that. In other words, what the court is saying is, look, we are going to consider the logical reasoning process of this expert's report. If the expert's report contains that there's a body of opinion that shares that view, the court will then examine the logical reasoning of that body of opinion. It's not just bound because a body of doctors believes that this is the right standard. The court will go deeper and look at the logical arguments underpinning that. However, it will usually be the case that the court will be guided by the expert witness. The occasions on which a body of opinion will not be followed by the courts is somewhat rare. I'm going to put it there. Put it the other way around. In the vast majority of cases, the courts will follow the genuinely held, competent views of an expert, and even more so where there's a body of medical opinion supporting it. So in most cases, if there's a body of opinion, the courts will accept that as the benchmark standard. However, the important point to emphasize is the court will not just simply blindly follow that. The important point to again emphasize is that the court will want to look at logical reasoning. That's the heart of the process of what's happening in court. Let's look at JA on behalf of DMA versus Member of Executive Council for Health Eastern Cape. Van Zyl, Deputy Judge President, writing for the full bench. In other words, this is a three-judge decision. So it has more weight because it's written by 3 judges. Dealt with the evaluation of conflicting evidence, concludes as follows at paragraph 17 thereof. So this is now when you've got conflicting evidence between experts. We've had a look at the importance of logical reasoning. How does the court approach a conflict between experts? So, in general, it is important to bear in mind that it is ultimately the task of the court to determine the probative value of expert evidence placed before it and to make its own finding with regards to the issues raised. So that's re-emphasizing the principle in Michael, right? Michael's case. Faced with a conflict in the expert testimony of the opposing parties, the court, what do they do when there's a conflict, however? And here this case tells us. The court is required to justify its preference for one opinion over another by a careful and critical evaluation thereof. Further, the primary function of an expert witness is to guide the court to a correct decision on questions which fall within that expert's specialized field. To that extent, the expert witness has a duty to provide the court with abstract or general knowledge concerning his or her discipline and the criteria necessary to enable the court to form its own independent judgment by the application of the criteria to the facts proven in evidence. Accordingly, the mere pitting of one hypothesis against another does not constitute the discharge of the functions of an expert. What's the court saying? You can't just pitch your hypothesis, your pet view, or your finding of a case against the other expert. You must go further. As an expert, you have a duty to provide the court with abstract or general knowledge concerning your discipline. In other words, to put the court in the picture as far as your discipline is concerned, and the criteria necessary to enable the court to form its own independent judgment. So you are, remember the court used the words a guide. The expert is a guide to the court to find correct decisions on questions which fall within that expert's specialized field. You're guiding the court, in a sense, educating the court, explaining to the court what that abstract or general knowledge relating to the case is, and giving the court the ability to then form its own independent judgment by the application of the criteria to the facts proved in evidence. Very important to understand this interrelationship between expert and the court. What's going on? The expert is guiding the court to the court's own independent judgment. As I said earlier, and we saw in the principles in Michael's case, the court should not and does not simply follow it, be led by the nose by an expert. It must independently apply its own mind, and that is what happens in the overwhelming majority of cases. And to be a successful expert, you must be able to take the court through your reasoning, be able to get the court to follow what you're saying, and what you're saying must be correct on the facts and correct from a legal perspective, where you'll have to be helped by your legal representatives, but correct on your clinical abstract or general knowledge background. Very important dictum from this judgment. And here it is a development of those principles. It sort of ties everything together to me. So here we have, finally, it is not the function of the court to develop its own theory or thesis and to introduce on its own accord evidence that is otherwise founded on special knowledge and skill. By its very nature, such evidence is outside the learning of the court. The function of the court is restricted to deciding a matter on the evidence placed before it by the parties, and to choose between conflicting expert evidence, or accepting or rejecting the proffered expert evidence. What is this principle? The courts also have rules, and there's also a limit to the powers of the courts. Judges cannot simply do what they want to do. They are also bound by principles and rules which all tie into this process of logical reasoning. The judge cannot just come up with their own pet theory or thesis of the case and introduce on their own accord evidence that they want. They can't be a loose cannon. The judge's decision must fall within what the experts are saying, or the judge must reject that expert evidence in its totality. And then there will probably be a finding that the plaintiff hadn't proved its case. So very important. Next slide. An expert's opinion represents his reasoned conclusion based on certain facts or data which are either common cause or established by his own evidence or that of some other competent witness. Except possibly where it is not controverted, an expert's bald statement of his opinion is not of any real assistance. So again, you need to explain why you hold an opinion. Let's turn to this, applying those principles to this case. One, I'm not going to take you through all of that. You can pause the video and look at it. I'm just mindful of time. So those were the facts that were found in the case. The court then investigated what informed the opinion of Dr. N that the injury to the sciatic nerve was caused by the incorrect or careless placement of a retractor, despite the denial thereof by the defendant. The court states that Dr. N was, during his evidence in chief, referred to medical articles which appeared to postulate that incorrect retractor placement was one of the main causes of sciatic nerve damage. A closer reading of the review article by Unwin and Scott showed that it dealt with not only sciatic nerve palsy after hip replacement, but also with damage to the femoral and obturator nerves. The article suggests that traction, which had been ruled out in this case, remember we saw that in the beginning, was probably the most common cause for sciatic nerve injury. Placement of a retractor over the anterior lip of the acetabulum was the principal cause of damage to the femoral nerve. Reliance by the plaintiff in this article for the contention that retractor placement is the most common or obvious cause of sciatic nerve injury was, therefore, in the court's view, unfounded. The same could be said of the other articles the bundle provided. In other words, what are we seeing in practice here? Here's the court assessing the logic of the expert's opinion and finding, for reasons set out here and in the judgment, that the expert's opinion was in fact not logical. The conclusion didn't follow from the facts for the reasons set out in this paragraph. Court went on to say that was not to say that incorrect or prolonged retractor placement should automatically be ruled out as a cause for the complaint. The experts agreed that incorrect retractor placement could cause sciatic nerve damage either temporarily or permanently. The issue was whether it was the most plausible cause of the plaintiff's injury, there being no factual evidence regarding the mechanism of the injury. That's important. No factual evidence regarding the mechanism of the injury. Was it the most plausible cause? In other words, balance of probabilities. Has the plaintiff discharged the onus on her? The court held that, with all due respect to Dr. N, his attempts at explaining the cause of 3 other drop foot cases, despite him taking the utmost care in those instances, did not assist the plaintiff. Neither did his because they were different cases. Neither did his proposition that because the plaintiff presented with a drop foot after the operation, the defendant must have been negligent, which was not only apparent from Dr. N's evidence, but also from the 2 reports compiled by him and Dr. B during 2016 and 2017. In other words, simply by virtue of the fact that there was drop foot, there must have been negligence. The court rejected that, wherein the probable cause of the injury to the plaintiff was not addressed at all, save to state that the defendant did not take due care during the procedure. Now, there we go back to, do you see the difference there? Probable cause, that's causation. not dealt with at all. Save to state the defendant did not take due care during the procedure. That's negligence. Remember, we looked at you need both. You can't just say the practitioner was not up to scratch. You have to show that that failure to be up to scratch led to the injury. And it's logical. Because if you're not up to scratch but it didn't cause any injury, what's the relevance? You can't have a judgment against you just because you were negligent, as I say, in the air. You have to show that it caused an injury. Mr. Williams, SC, I didn't put in SC, I apologize to Mr. Williams, sought to draw a parallel between the present matter and Van Vollenhoven versus Dr. J.C. M. Venter, in which the plaintiff incurred an injury to the perineal aspect of the sciatic nerve during a THR, which left her with a dropped foot. Low J reiterated the golden rule, which applies to THR procedures, i.e., that at all stages care has to be used to protect the sciatic nerve. The surgeon has to be aware of the location of the nerve, if not visually, then by palpation. Especially great care should be taken to position retractors to avoid injury to the sciatic nerve. In the Van Vollenhoven matter, the court held on the probabilities that the placement of the retractor caused the injury to the plaintiff's sciatic nerve. In other words, in Van Vollenhoven, the court looked at the evidence and decided, you know what, the placement of the retractors in this case probably led to the injury. That's critical. In that matter, as in the present case, placement of the retractors was done by the defendant alone. The court held that the resultant damage showed that the defendant did not exercise proper skill and care in protecting the sciatic nerve. There's your negligence. Didn't exercise proper skill and care, therefore didn't act as a reasonable surgeon should have, therefore negligence. The court rejected the evidence of the defendant's expert that the defendant had performed the procedure with proper skill and care, not negligence, because it was based solely on the good reputation of the defendant and the fact that the defendant had demonstrated his excellent knowledge, skill and care in performing such an operation during a consultation with a Professor W using a plastic model. The defendant's expert was found to be biased, incidentally. Then, importantly, the court found that Van Vollenhoven could, however, be distinguished from the present case in the following respects. 1. The mechanism of the injury was not in dispute. The defendant from the outset expressed his view to the plaintiff that a retractor pressed on the sciatic nerve during the operation caused the injury, it should be. He confirmed during cross-examination that the most probable cause of the injury was that the retractor pushed too hard against the sciatic nerve, and 2, there did not appear to have been any scientific evidence as to other possible causes or risk factors involved in such a procedure. What does that mean? That the mechanism of the injury was established and that it was the placement of the retractor. Dr. J was criticized for not being objective, that he excluded retractor damage on the say-so of the defendant, that he kicked up dust by postulating all kinds of possibilities, not probabilities, and that his opinion was rooted in a scientific approach, and that a judicial measure approach should be applied and not a scientific measure. Interesting in that paragraph, look at the types of attacks that an expert witness comes under. Very well worth bearing in mind. Mr. Williams referred in this regard to the JA on behalf of DMA matter, where it was stated at paragraph 50. The burden of proof in a civil case requires a plaintiff to prove his case no higher than on a balance of probabilities. The probabilities are determined upon the facts and an element of experience and common sense. It calls for a sensible retrospective analysis of what would probably have occurred based upon the evidence and what can be expected to occur in the ordinary course. Applying the standard of proof to the test for factual causation, the inquiry is directed at identifying the more plausible of any one cause against the backdrop of the negligent act found proved, including the available evidence as a whole, which in a matter such as the present will include, but is not limited to, expert opinion. In other words, once you've got the negligent act having been established, then you look at the background, and then you apply the standard of proof as to whether it's established that that negligent act probably caused the injury. That's what this all gets down to. In Linksfield, the court pointed to the fact that expert scientific witnesses tend to assess the likelihood of something in terms of scientific certainty. Now, experienced experts will have been warned of this, and it's well known, but here's a practical application of it. and stated that the essential difference between the scientific and judicial measure of proof was aptly highlighted by the House of Lords in the Scottish case of Dingley versus the Chief Constable Strathclyde Police, and the warning given that one cannot entirely discount the risk that by immersing himself in every detail and by looking deeply into the minds of experts, a judge may be seduced into a position where he or she applies to the expert evidence the standards which the expert himself will apply to the question whether a particular thesis has been proved or disproved. In other words, the scientific measure. Instead of assessing, as a judge must do, where the balance of probabilities lies on a review of the whole of the evidence. In other words, all this means is that judges must be careful not to get drawn into the niceties of scientific proof, but must always remember that you look at the totality of the evidence, including the expert evidence, and you then come to a sensible assessment of what is the most likely cause of the injury. That's what it boils down to. The court in Van Wyk concluded by finding that this was not a matter where one would be tempted to assess the evidence in terms of scientific certainty. A mere analysis of the cogency and underlying reasoning for the opinions of the experts sufficed. Dr. J's disregard of direct retractor compression as a cause for the injury was not just on the say-so of the defendant, but because the injury was atypical of a retractor injury. This evidence was not contested by the plaintiff. The experts were ad idem, in other words, in agreement, that in 50% of sciatic nerve injuries, the cause thereof was unknown. There was no factual evidence that the injury was caused by incorrect retractor placement critical. The explanation by Dr. J of the impact of anatomical variance with regard to sciatic nerve injury is not only logical, but is underpinned by the medical literature. Dr. N acknowledged these variants, but disregarded it as a cause or a risk factor without giving any reasonable explanation for his dissent with the results of medical research. Therefore, you can see he's going to have a problem with his logical reasoning. The court found further that against the logical and well-reasoned testimony of Dr. J, the cause of the plaintiff's sciatic nerve injury fell within the 50% of cases which are unknown. Dr. N's bold opinion that the injury was most likely caused by a retractor because it is always used and is a dangerous instrument known to cause damage could not prevail. Simply because a retractor is always used, simply because it's potentially dangerous, does not mean that you've proven causation. You have to show that it was the most likely cause. And the court therefore held that the plaintiff had therefore failed to show on a balance of probabilities that incorrect and careless placement of a retractor had caused the injury to the plaintiff's sciatic nerve. As a result, the claim was dismissed. All right, just in closing then, as you can see from this case, there's a lot locked up into this case, but it's a fantastic example of how the courts assess expert evidence, differences between experts, the importance, how the approach to expert evidence, which is to look for that logical reasoning, interlocks with causation, interlocks with negligence, and then the test of the balance of probabilities or most likely cause, if you like. Anything that's been established doesn't have to just be the cause, could be the negligence, must be established on a balance of probabilities. In other words, must be the most likely cause, over 50%, put it that way. You have to meet that burden of establishing 50% plus 1, what's called a preponderance of probabilities or balance of probabilities. That's always your test to establish causation, negligence. If wrongfulness comes into it, that didn't come up in this case, but anything that needs to be established in a civil case, it's on a balance of probabilities. And this case then brought all those interlocking pieces together in a very useful way. The dispute between experts and the way that that's approached also comes through. So a fantastic initial case. I hope that you found that of interest and of benefit. Just a word, if you feel that it's a bit overwhelming on the amount of information, I would understand that. Remember that it is that these concepts get dealt with a lot. So as you get exposed to more and more case law, you'll become more and more familiar with the workings of these concepts. But I think it's very useful to have an introduction to all these. These are many of the key concepts when it comes to expert evidence locked up in this judgment. So I hope you enjoyed that. A little longer than I expected it to be, but I think it was worth exploring it in some detail. And we will chat soon in the next video.